My name is Sally Engel-Mary, and I am actually the Silver Professor of Anthropology at New York University, and I have done a lot of research on human rights and legal anthropology, where anthropology likes to kind of destabilize existing categories like gender and rights. Lawyers want to clarify categories and define things. So there's a deep tension between these two fields, which is quite interesting.
Welcome everyone to our webinar in honor of Sally Engel-Mary. I'm really happy to see a lot of familiar faces and some new faces. I'm really looking forward to today's session. We have a really interesting paper by Sandhya Fuchs, and Natasha Raheja has kindly agreed to discuss her paper. And before I hand over to Sandhya, let me just introduce her and also Natasha. So Sandhya's research explores the relationship between law, experiences of violence and hate, and social imaginaries of hope, justice, and truth. Located at the intersection of anthropology and critical legal studies, her work analyzes the potential of anti-discrimination and hate crime legislation to address structural inequalities and counteract culturally specific forms of prejudice and oppression. Sandhya has completed her PhD, which examined the social life of India's ambitious Prevention of Atrocities Act, which she's going to talk about today, at the London School of Economics in Social Anthropology in 2020, so recently, congratulations. And she's affiliated there with the International Inequalities Institute. Currently, she works as a research associate at the University of Bern in Switzerland and teaches a course called Injuries on the Margins, Hate Crimes, Recognition and Legal Remedies, which sounds really interesting. So thank you very much for agreeing to present today, Sandhya. And let me also introduce Natasha. Natasha Raheja is a visual and legal anthropologist, which I think is a great combination and still too rare in anthropology. She works as an assistant professor of anthropology at Cornell University. She received her PhD in anthropology from NYU in 2018. And her current writing and film projects explore questions of migration, citizenship, and majoritarianism in South Asia. So I think she's an ideal discussant to Sandhya's work. And she currently works on her book manuscript entitled From Minority to Majority, Pakistani Hindu Claims to Indian Citizenship. So welcome everyone again, and with this I'll hand over to Sandhya. We're really looking forward to hearing your paper, Kaleidoscopes of Truth.
Thank you so much for having me. And yes, hello everybody. Okay, I have a PowerPoint presentation that I'm just going to share. It's just also some photos and things. Okay. In March 2018, the Indian Supreme Court issued new guidelines to prevent what it deemed the rampant misuse of the 1989 Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act. India's highest court declared that 15% of all complaints filed under the Atrocities Act amounted to false accusations, and that the law had become a vehicle for blackmail wielded against innocent members of the upper castes by ex-untouchable and tribal groups. Consequently, the Supreme Court warned that rather than eliminating casteism and injustice, the law was in danger of promoting it. In response to the judgment, protests broke out across India. Afraid to lose political support, the Indian Parliament passed the 2018 Prevention of Atrocities Amendment Act in August 2018, which restored the Atrocities Act to its original shape. But what precisely is the Prevention of Atrocities Act, and how is it able to engender such contradictory perspectives and emotions? The Atrocities Act is arguably one of the most ambitious examples of protectionist criminal legislation in India and worldwide. Situated at the intersection of hate crime and anti-discrimination law, and heralded once as a unique effort to address prejudice and violence on the basis of caste and indigenous identity, the Atrocities Act aims to prosecute, prevent, and punish violence against Dalits, which are ex-untouchable groups, and tribal groups called Adivasis, by upper castes. While India's constitution banned the practice of untouchability in 1950, the Atrocities Act represents the first law to explicitly define all physical, political, ritual, and symbolic violence against Dalits and Adivasis as criminal acts or atrocities, and to outline strict punishments for such misconduct. However, 30 years after its implementation, scholars have questioned the ability of the Act to generate fundamental social change, as most cases registered under the Atrocities Act never make it to court, and a negligible number lead to conviction. The Dalit rights organization Swadikar has argued that deep-seated caste bias within police and judiciary have paralyzed the Act and caused it to fail. These assessments are diametrically opposed to the opinion expressed in the 2018 Supreme Court judgment. The judgment characterizes the Atrocities Act as a vehicle for fraud, while the former emphasized the Act's inability to live up to its promise of societal transformation. We therefore have to wonder what lies behind these oppositional assessments. Indian political scientist Sabir Kora has emphasized that the formal truth or falsity of complaints filed under the Atrocities Act is essentially contingent on the police's decision to either forward a complaint to the courts or dismiss it after the investigation with a final report, which essentially deems an incident unworthy of further investigation or litigation. This decision involves a high level of police discretion. Consequently, critics have encouraged the Supreme Court to consider the institutional dynamics behind so-called false cases more closely. Yet, as it currently stands, the continuing controversy over false cases still begs some of the most fundamental questions. What makes a case true or false in the first place? What is legally needed to render an atrocities case true? And is this congruent with the perceptions and expressions of truth and discrimination that circulate among Dalit and Adivasi communities? And what lived and experiential consequences does the persistent discourse around false cases create in the lives of those turning to the Atrocities Act for protection? Implicit in the initial Supreme Court declaration are three claims. First, judges display a binary understanding of case truth and falsity. Secondly, the tone of the judgment suggests that the Supreme Court is confident in the ability of the legal apparatus and the tenets of criminal practice to distinguish effectively between true and false claims. Finally, the judge's reprimand of those who misuse the Atrocities Act highlights its conviction that victims of caste-based atrocities can access and mobilize the Atrocities Act by adhering to legal procedure. In the Supreme Court's eyes, personal truth in the sense of a true experience of discrimination or violence or hate begets legal truth in form of a conviction or a hearing. Yet the stories I uncovered during 18 months of fieldwork with Dalit atrocity survivors in the Indian state of Rajasthan tell a different story. And I've just put up a map of India, obviously, and then this is a district map of Rajasthan here on the left. The yellow and the red zones are the main research regions that I kind of followed atrocity cases in. And the red region is actually the Jhunjhunu, is where all of the cases we're discussing today are from. As I traced atrocity complaints from their communities of origin to police stations and courts, the experiences my Dalit interlocutors shared challenged all of the Supreme Court's assumptions. In this paper, I specifically zoom in on the Supreme Court canon of false accusations and examine the claim that Dalits and Adivasis, as the beneficiaries of the Atrocities Act, regularly misuse the law for personal gain. I explore what Foucault once called the competing regimes of truth that govern the legal and social life of the Atrocities Act, to interrogate the dichotomy between false and true cases and explore how historical and social realities can become legal falsehoods and vice versa. Specifically, I ask how binary options of case truth or falsity interact with the contextual and historicized perceptions of marginalized realities that steer the engagement of Dalits with the Atrocities Act as an anti-discrimination measure. I propose that, ironically, Dalit engagement with the Atrocities Act reveals that the problem of false cases largely arises from two conceptual and practical contradictions within legal attempts to target hate and discrimination. First, as Pratiksha Bakshi argues, the Atrocities Act is caught up in the same field of power it is meant to address. Many Dalit atrocity survivors lack social and financial capital and are thus excluded from processes of successful evidence production. Decades of marginalization within the Hindu caste system have put many Dalits in a position where they are easily ignored by the institutions that create proof in courts, such as hospitals, police stations, and forensic labs. As a result, the efforts of most of my Dalit interlocutors to mobilize the Atrocities Act and to provide the kind of evidence courts want, or even the police, were in vain. Meanwhile, members of upper caste who threatened them or hurt them were typically much more well-connected and financially resourceful. Secondly, the conundrum of false cases arises from the competing visions Dalit communities and legal actors project onto the Atrocities Act and the different ways in which they think caste-based violence should be evaluated within a legal system. In central ways, the present focused and abstracted criminal framework of individual atrocity cases into which the act pours violence against Dalits is simply incompatible with its goal of identifying and alleviating historical and structural discrimination. Nicola Lacey argues that discrimination is an everyday occurrence, which only becomes evident when incidents are analyzed within a longer social and collective history, while Benjamin Bowling argues that hate is not event, but process. In short, discriminatory violence can only be detected, understood, and made visible when actions are evaluated against the particular landscape of historical interactions which have exposed certain groups to a unique kind of violence and exclusion. However, police and courts in Rajasthan rarely approached atrocity cases in this way, disregarding longer histories of interaction between castes and insisting that caste-based intent needed to be apparent in the reported moment. Crucially, this incompatibility ultimately produces the very illegality the Supreme Court aims to counteract. During my fieldwork, Dalits sometimes abused the Atrocities Act, to use the Supreme Court's words, in a hopeful effort to hold this unique law accountable to what they perceive as its promise of equaling the playing field of caste and social power, and of alleviating hardship that is fundamentally historical, social, and structural. In this process, what registers as a false case within the fissures of India's legal administration can often speak to deep truths of disadvantage and discriminations, and even sometimes to deeper ones than cases that have been stamped true by the courts. I explore these contradictions by discussing 3 cases that were filed under the Atrocities Act in Rajasthan. First, we will accompany a Dalit laborer whose father was likely murdered by his upper caste employer on his doomed quest for evidence. Then we will discuss Anil, who filed a legally fraudulent complaint under the Atrocities Act, which nevertheless spoke truth to his family's reality of disadvantage. Finally, we follow Shiv Kumar, a de facto Dalit village head who achieved the rare feat of winning an atrocity case under the Atrocities Act through his clever, yet sometimes dishonest, navigation of the evidential landscape. All incidents took place in Rajasthan's Jhunjhunu district between 2016 and 2017, and in all cases, the complainants are Dalits of the Meghwal subcaste. The accused parties, Jats and Gujars, represent the most socially and economically influential caste groups in their respective villages. A quest for evidence. In March 2017, I paid a visit to the village of Puranapura in Rajasthan's Jhunjhunu district. Economically and socially, Puranapura is dominated by members of the Jat caste, a farming community that constitutes the single largest caste group in the village and controls almost 70% of fertile agricultural land. Puranapura also claims a significant Dalit population of around 300 individuals, over half of which belong to the Meghwal community. Many Meghwals make a living as agricultural laborers and have become increasingly dependent on the growing might of Jat landowners who control access to agricultural employment. That day, I set out to meet a man who had experienced the consequences of this dependency firsthand. Rajendra Meghwal, son of the recently deceased Phularam Meghwal. In February of the previous year, Phularam had been found dead on the field of his Jat employer, El Kateria, in the aftermath of a wage dispute. According to Rajendra Meghwal, his father's body had borne the marks of torture. And there were witness statements to suggest that Kateria had been responsible for Phularam's sudden passing. A Meghwal friend of Rajendra's called Vivek, who worked for a Jat family whose house was right next to Kateria's field, had heard screaming in the middle of the fateful night when Phularam had died. Vivek had overheard Kateria verbally abuse somebody, followed by very strange cries. The next day, as the news of Phularam's death spread through the village, Vivek began to wonder whether there was a connection. Armed with this knowledge, Rajendra and his mother, Gyarsi Devi, filed a complaint at the police station. The complaint was correctly registered under the Indian Penal Code, accusing Kateria of conspiracy and murder. However, the police initially refused to file the complaint under the Atrocities Act, which enhances punishments for certain criminal offenses under the Indian Penal Code when they are committed against Dalits or Adivasis. When Rajendra insisted, the officers finally obliged. However, he later learned that they had incorrectly listed the incident under a section of the Atrocities Act that merely cited caste-based hate speech. And Rajendra is illiterate, so he couldn't actually read the report. One of the police officers told me later that he didn't think the incident was at all motivated by caste, and that therefore he felt uncomfortable applying the draconian Atrocities Act. He also didn't think the wage dispute between Phularam and Rajendra was relevant to the case. Hence, the report failed to capture the gravity and complexity of the accusations leveled against Kateria. The police told Rajendra and his family that Phularam's body would be examined at the local hospital as part of the official investigation and then be shipped to Jaipur, the capital, for an autopsy. However, 2 weeks later, Rajendra was informed that the police investigation had shown his father's death to be of natural causes. Consequently, the case was not forwarded to the courts and closed with a final report which effectively declared it a false accusation or a mistake of fact. The police file Rajendra gained access to with the help of a legal aid NGO contained a statement from the local hospital which stated that heart failure was the most likely culprit of Phularam's passing. But there was no autopsy report. Incensed, Rajendra traveled to the state capital of Jaipur to procure the autopsy report himself. He was told that the report was still pending. That made little sense, considering that the police investigation had been closed. Rajendra was sure that Kateria had something to do with his father's death, especially because of the ongoing wage dispute. Having seen his father's body, he also knew that the medical report was a lie. But he couldn't prove any of it. Vivek, who had overheard the screaming in the fields, absolutely refused to testify at the police station or publicly. "Are you crazy?" he told Rajendra. "Kateria has so much influence and money. I say anything, and next thing, my family finds my body in the fields." By the time I arrived in the village of Puranapura to speak to Rajendra's family, it was an open secret in the community that Kateria had paid the police to drop the investigation into Phularam's case. However, Rajendra believed that the money wasn't even necessary. Kateria's brother-in-law was a member of Rajasthan's legislative assembly, he says. The family owns a ton of property and is still very powerful in local business and politics. Police or anybody doesn't want to mess with that family. Rajendra has a veritable mountain of documents relating to his father's death. Copies of the initial police report, copies of the medical report, newspaper clippings, a call for action circulated by the Center for Dalit Rights regarding Fularam's mysterious death, all his tickets from his bus travels all over Rajasthan to procure evidence, and even a letter from the hospital in Jaipur regarding the pending status of the autopsy report. Basically, Rajendra laughs bitterly, I have all the evidence, I have tons of evidence, that I have no evidence. People always say that Dalits don't know anything about the law, but I actually know a lot, I've learned a lot. The problem is that the evidence judges want is the kind of proof a man like me can never get in the first place. Because proof is something only available to the right people who can make the police work and make them produce it and later get taken seriously by judges. With a few sentences, Rajendra had called into question the very value of a measure like the Atrocities Act. His father's case is now one of the many false cases cited by the Supreme Court. Yet Rajendra's story cements lingering doubts about simplistic claims regarding Dalit misuse of the Atrocities Act and shows that the arena of legal evidence is hardly an even playing field. Bruno Latour once proposed that when assessing evidence in legal cases, judges do not reason, but instead grapple with the file that acts upon them. He explains that in order to produce verdicts, legal professionals need to harvest files when they are ripe. This ripeness is defined by both the quantity and quality of information contained within the file. Unfortunately, as Rajendra pointed out, his father's file was not a file that would ever be given a chance to ripen, because he himself was the wrong kind of person to procure statements and materials that count as evidence, or to engage the institutions and people that produce them and act as gatekeepers to the courts. In a setting where, as Vivek pointed out, police investigations go to the highest bidder, Rajendra's family had neither the financial means to buy police support nor the social capital to force the corporation of the hospital. Tobias Kelly proposed that documents can be manipulated in ways that call narratives of universal legal rationality into question. Similarly, the evidence men like Rajendra need is far from objective. In atrocity cases, ripe files are considered carriers of proof and truth, even though documents and the police officials who collect them are shaped by the very relations of power the Atrocities Act is meant to change. Rajendra's remark that all he can really prove is that he has no proof betrays the uncomfortable truth that the institutional channels Indian state law has elevated to the position of official proof producers and truth producers are accessible and manipulatable to vastly different degrees by different types of people. This reality can turn the Atrocities Act, a law meant to address hate and discrimination, against itself. As Beth Goldblatt points out, the contextually specific intersectional forms of violence marginalized groups, in this case Dalits, experience can only qualify as discriminatory in the eyes of the law when actions are evaluated against the broader landscape of social interactions that have left these groups isolated within social and political institutions and within society as a whole. Moreover, Ellis and Watson warned that a legal system which outlaws discrimination has to be acutely aware of the many different ways in which discrimination manifests itself and shapes engagements with legal actors and institutions that are meant to address discrimination. Rajendra's story illustrates that in atrocity cases, the search for good and ripe legal files regularly excludes socioeconomically disadvantaged Dalit complainants from engaging the very law meant for their protection. The inability to procure the right evidence, often due to obstruction by institutional gatekeepers, makes it easy to dismiss their complaints as false. In Rajendra's case, the institutions he had to rely on for the obtainment of proof were politically and financially controlled by the family he was trying to battle in court. Rajendra was beginning to realize this, but he still wished very deeply that he could trust the process. Other Dalits, however, had learned to treat the law more strategically. when truth splits, a false case captures the village. In October 2017, my own fieldwork village of Nyasad witnessed an uproar when 4 young men, 2 Dalit and 2 Muslim, were unceremoniously arrested in a clash with Nyasad's wealthiest Jat landowner, Pokaram. However, 3 weeks later, all 4 men were then mysteriously released by the police, and Pokaram was strangely reluctant to discuss the matter. To get first-hand information on the case, Suman, a Dalit women's activist whose family I lived with in Nyasad, suggested that we pay a visit to Bantu Meghwal, the Dalit lawyer who had represented the main accused, Anil Meghwal, in the controversy. It appeared that on the day of the arrest, Anil and 3 of his friends had made their way to a large wheat field at the edge of Nyasad with some bottles of whiskey. The field belonged to Pokaram Jat, and the young men quickly became intoxicated. Pokaram's tenants living near the field witnessed the scene of drunkenness and phoned Pokaram, who promptly made his way over on his motorcycle. Pokaram personally knew Anil and shouted at him to get off his land immediately. In his drunken state, Anil picked up a stone from the road and smashed it against Pokaram's head, leaving him injured. As Anil and the other boys fled the scene, Pokaram's tenants called his family to make sure that he was brought to the hospital. After Pokaram was discharged, he called the police, and within hours of the phone call, Anil and the other boys were arrested for attempted manslaughter. No one in the village thought Anil innocent in this situation, not his family, and certainly not his lawyer, Bantu Meghwal. Look, Pokaram was clearly in the right here, his lawyer said. The problem is Pokaram's power and how it was going to affect the boys' families. Pokaram, who harbored political ambitions, was not only economically very well off, but also exceptionally well connected. Attacking Pokaram was therefore, to use Bantu's words, not only morally wrong, but also strategically idiotic. Anil and the others would have spent their entire lives in jail without interrogation or anything, had I not intervened, Bantu is convinced. Indeed, it had seemed at the time that the police were in absolutely no hurry to interview the boys or process an investigation or their case. They simply kept them in custody, refusing to take the boys' statements or family statements or to provide any further information to absolutely anyone. The situation soon proved detrimental to the boys' families. All 4 boys had fathers who worked abroad, and their mothers and sisters relied on the boys for help working the fields as well as for daily income and personal protection. Lawyer Bantu Meghwal therefore gave Anil a simple piece of advice. He told him that if he wanted to get out of jail, he would have to file a case under the Atrocities Act and accuse Pokaram of casteist hate speech. Pokaram would be humiliated and worried about his ability to secure votes in the upcoming, secure votes in his run for a seat in the Legislative Assembly. Bantu's plan was a flawless tactical move. As soon as he got wind of the atrocity case complaint filed against him, Pokaram dropped the charges against the boys. All parties struck a compromise. The boys would be let go, and in turn apologize to Pokaram, leave his fields alone forever, withdraw their atrocity case, and never mention the matter again. Anil's story sits uncomfortably. An irresponsible attack on an older higher caste man by drunken Dalit youths, and a shrewd lawyer who mobilizes a hate crime law as a revenge plot or a negotiation tactic. Nyasad's Meghwals and Anil's family are deeply ashamed of the story. Bittu auntie, one of Suman's neighbors, commented, look, people like Suman, who you live with, defend those who really, really suffer from caste violence. And here you have Anil getting drunk and needing to be gotten out of jail because otherwise his poor mother is destitute. Next time there is a real atrocity complained, nobody is going to believe it because Anil made it all up. But what to do? If Boko Haram had it his way, they would have all died in jail, and he has engaged in hate speech before. On the surface, the facts are clear. Boko Haram did not use caste-based insults when reprimanding the boys that day, and lawyer Bantu Megwal readily admits that. Legally, the case is false, and the accusation is untrue. However, Nayasar's Megwal often stressed that one needed to consider that had the situation been reversed, Boko Haram would never have been arrested as unceremoniously as Anil and his friends. They thought that the existential threat the boys' arrest posed to their families and Boko Haram's history and status needed to be taken into account when judging Anil's and Bantu's strategy. Therefore, they concluded that the case was bigger than Anil's wrongdoing. The dynamics that unfolded during the arrest and the dynamics that shaped police action, they thought mirrored the unequal power dynamics between the land-owning and politically influential Jats in the village and the Megwals, who only owned small plots and often depended on emergency loans from Jats. Had Anil called the police on Boko Haram, Bantu Megwal spelled out the situation, the police would not have come. They would never have arrested Boko Haram, even if he had drunkenly murdered Anil with an axe in broad daylight. No one arrests Boko Haram. And he has said disparaging things about Dalits in the past. Oh, there we go. Turning our attention back to the Supreme Court's concern with false atrocity cases, Anil's out of jail free pass hence represents an instance that splits the idea of truth into an immediate, factual, and legal one, and a contextual, historical, and social aspect of veracity. Legally, Nayasar's Megwal say Anil's atrocity case was a false one. However, his tactical release cannot be judged or evaluated in a vacuum, but must be seen against the backdrop of the historical hierarchies of socio-political power that the Atrocities Act is meant to change. Law, as many scholars have pointed out, is itself founded in systems of political power, which construct the legal in its service. The parameters of legal procedure and its relevant institutions are hence skewed inherently against men like Anil, while Boko Haram's historical standing and social influence situate him advantageously in navigating the police and the legal arena. The historical disadvantage that marks Anil's life means that he has to engage in illegal action sometimes if he hopes to receive equal treatment from institutions like the police. To use the words of Matei and Nader, law is a double-edged sword, which concurrently favors oppression and produces empowerment. The attitudes Nayasar's Megwal's display towards the false case is one that takes law as an instrument for the rectification of deeper structural inequalities. They regard the Atrocities Act as a method to navigate caste-related power differentials themselves, rather than to solve a case abstracted from particulars. For Megwal's engagement with the Atrocities Act is based on their understanding of the Act's intent, which is to equal the social playing field of caste power. Thus, they neither regarded Anil's case as entirely unjust or entirely untrue. Megwal attitudes run directly counter to the outlook of most judges in Rajasthan, who aim to generate rulings based on what they often consider comparable and evidential insight. However, this objection still begs the question: when followed, do the proper procedures, the evidential procedures stipulated in Indian criminal law and the Atrocities Act, actually allow for legitimate detection of a true experience or a false experience of discrimination? a sarpanch goes to court. In April 2016, a shocking incident occurred in Rava village in Jhunjhunu. Rava is dominated by the Gujar community, a farming caste which, like the Jats, acquired significant agricultural wealth in the aftermath of the post-independence land reforms. In 2016, Rava was declared a reserved constituency in the local village council elections, which means that the position of village head or sarpanch had been reserved for a member of the scheduled caste, which means a Dalit, and in this case, specifically for a Dalit woman. The village elected Srimati Rekha Devi, wife of Shiv Kumar Meghwal, a Dalit lawyer and the son of a police officer who owned 12 hectares of land. Not long after the elections, Shiv Kumar filed a complaint in his wife Rekha's name under the Atrocities Act at the nearest police station. The complaint accused a Gujar woman named Pooja, the local kindergarten worker, and wife of Rava resident Babulal Gujar, of casteist hate speech and assault. Rekha had been walking home from the fields, she says, when she was suddenly held back by Pooja. Pooja reportedly grabbed Rekha's arm and accused her of pocketing government money provided for the construction of proper toilets. You dirty Jamar, and Jamar is a derogatory term used to describe Dalits. We can talk about that more in the question if anybody wants to learn about it. But you dirty Jamar, who grew up in the gutter, she screamed at Rekha, I will teach you how to be a sarpanch. Rekha returned humiliated. Rekha returned home humiliated. The Meghwals in the village believed that Pooja's anger had been triggered by Rekha's decision to forward villagers' complaints about Pooja's professional misconduct to the block secretary. At the police station, Shiv Kumar was seen promptly when he went to register his wife's complaint. Many of the officers remembered his father, one of the first Dalits in the area to hold an inspector post in the nearby town of Jirava. The police carried out their investigation within the week, wrote up a detailed report, including witness statements supporting Rekha's claims, and forwarded the case to the Jhunjhunu District Court. They also paid a visit to Babulal's house and scolded him and Pooja thoroughly. Shiv Kumar is very pleased when he recounts this part of the story to me. He's a man who has taken full advantage of the educational opportunities awarded by his father's social status and robust salary. He completed a law degree and for approximately a decade has worked as a contract lawyer. He takes open pleasure in the fact that Babulal and Pooja did not know who they were dealing with. I know everything about the law, he boasts. My father had many police contacts. I'm respected among Gujars even, and my wife is the sarpanch. Didn't Pooja miscalculate? In what Shiv Kumar describes as a desperate attempt to avoid court proceedings, Babulal Gujar's daughter filed a rape complaint against Shiv Kumar, which was promptly declared unfounded by the police. Soon after, Babulal's son-in-law registered another complaint against Shiv Kumar. Supposedly, Shiv Kumar's laughs, I beat him with slippers. The police threw out their complaint as well. Reality, however, is not so straightforward. You know, actually, me and some other guys did beat up Babulal Gujar and his son-in-law quite nicely. Shiv Kumar confided in me. But no one believed him, and he couldn't prove it because we didn't actually really injure him. That's how much influence I have. He even admits slightly embellishing the initial complaint. I mean, she didn't fully assault Rekha. She insulted her and she grabbed her. But I had them register it as assault because I want to show that people can't get away with treating Dalits like this anymore. We have power too now. In May 2018, 2 years after the incident, the case was ultimately decided in Rekha's and Shiv Kumar's favor, and Pooja was sentenced to a fine of 1 lakh, rupees, which is 100,000 rupees. Rekha's fate is unique, considering the low conviction rate under the Atrocities Act in Rajasthan, 4 to 5%, according to statistics released by the Center for Dalit Rights. Local Gujar support for Rekha's case indicates that power, defined as economic and political capital, directly impacts the outcome of atrocity cases. Shiv Kumar's assemblage of political and educational networks, his generational social ascension were impressive. His alliances were in place, Sarpanch power in his family's hands. As a result, witnesses were very willing to come forward and speak on Rekha's behalf. However, his rare win under the Atrocities Act partially also rests on moments of illegal action when he exaggerates Rekha's assault and beats up his opponent and influences the police not to take Babulal's counter cases seriously. Hence, it eventually weakens the foundations on which, according to the Supreme Court, legal justice rests, namely the claim to a proper, evidentially based legal process through which judges can distinguish crime from innocence, lie from falsehood, and map social realities of discrimination onto legal outcomes. Even though Shiv Kumar's situation appears opposed to Anil's, their acts of illegality are ultimately born out of similar motivations. More upwardly mobile than most Meghwal in his area, Shiv Kumar sees the Atrocities Act as a strategic tool to rectify established caste hierarchies. As a lawyer, Shiv Kumar argues that the Atrocities Act is not a law like others, but because of its anti-discrimination emphasis, it is a promise of evening the historical playing field of caste. The state, he tells me, has given me a weapon to fight and change caste dynamics from the bottom up. His sometimes legal use of the Atrocities Act thus springs from the feeling that this law should be primarily accountable to the historical truth of continued structural Dalit disadvantage. During our last meeting, he told me this: I lied about beating up Babulal, but he insulted my wife, and what I did to him is nothing compared to what people like him have done to people like me for generations. I lied, but there is truth in it. For Shiv Kumar, the primary point of the Atrocities Act is showing historical perpetrators of violence what it feels like to be a victim. Under the cloak of the Atrocities Act, Shiv Kumar enacts a form of caste impunity traditionally unattainable for people like himself. Comparing truths. A 2015 study published by the Indian Ministry of Justice found that many police officers and judges thought of the Atrocities Act as a personal revenge tool in the hands of Dalits and Adivasis, and were hesitant to take complaints seriously or convict those accused of the act. This dynamic is self-perpetuating and problematic in more ways than one. Ironically, in response to discouraging decisions at the police level, many Dalit atrocity survivors that I encountered felt that to actually have a chance at social justice or caste justice or fair compensation, they themselves actually couldn't be too bothered with immediate factual truth. Rather, they thought that they had to learn to beat law enforcement and powerful village elites at their own game. This can result in the circumvention of evidentiary procedures, or sometimes, as in Shiv Kumar's case, in the actual fabrication or amendment of particular facts. In short, in order to prove the continued contextual truth of their continued disadvantage, Dalits in Rajasthan sometimes ignored the legal way of using law. Latour also argued that legal truth is so light and so flat that it cannot be grasped by minds that want to get to the bottom of things, and has little root in the real world. The false atrocity cases I encountered during my fieldwork somewhat support this insight. Again and again, Dalits revealed their disillusionment with a legal evidence regime which granted them no real opportunity to speak to their experiences of discrimination and the dynamics that had shaped a specific incident, or forced them to depend on the cooperation of institutions like police, courts, and hospitals on which they had never held any sway. However, the way Dalits in Rajasthan engaged with the Atrocities Act also revealed something much more sinister. The flat truth of law can actually hide the very acts of illegality and falsehood the Supreme Court wants to counteract and make them appear true. Shiv Kumar's case is no truer than Rajendra's. Arguably, it is much less so. However, Shiv Kumar's access to law enforcement and his understanding of how and where rules can be mobilized and bent allowed his case to be true, while Rajendra's is false. It allowed Shiv Kumar to implement his vision of the Atrocities Act in a way that even someone like Anil never could. British hate crime scholar Mark Walters has proposed that the dissonance between lived realities of marginality and legal procedures of identifying and proving hate have engendered a deeply problematic justice gap, which runs the risk of replicating structural inequalities. Similarly, the journey of atrocity cases reveals that what registers as truth in atrocity courts is often the result of tactical institutional manipulations, or sometimes even fittingly formatted exaggerations that are hidden by the weavings of procedure. Paradoxically, then, the evidentiary demands of atrocity cases can render anti-discrimination measures blind to some types of illegality by arguably the people most in need, while making it hypervigilant to others, thus actually causing it to replicate structural inequalities. These challenges facing the Atrocities Act mirror critiques of protectionist legislation in other parts of the world, such as the United States and South Africa. In the USA, Brax and Munthi have pointed out that legal attempts to remedy hate and discrimination or prejudice unfold basic tensions and possible clashes between law, history, experience, and social values. Meanwhile, South African legal scholar Anton Kok has proposed that most anti-discrimination laws, with the explicit goal of undoing the effects of centuries of oppression and marginalization, can simply not cope with the depth and complexity of social prejudice. Such shortcomings are not theoretical, but have serious effects on the lives of those who turn to laws like the Atrocities Act for help. For many Dalit atrocity complainants who I talked to, the incompatibility between how legal truth was made and the contextual historical disadvantage that defined their reality and was more of a process engendered real feelings of procedural helplessness. When many of my interlocutors abused the Atrocities Act, they often did so in a hopeful effort to hold a law that symbolized so much to them to account and make it deliver on what they perceive to be this amazing promise of equaling the social playing field of power and of alleviating hardship. Conclusion. Rajendra, Anil, and Shiv Kumar's stories show how truth becomes an especially contested arena in the context of laws aimed at combating hate and deeper structures of discrimination. Dalit engagements with the Atrocities Act reveal that on the one hand, the issue of false cases arises from an incompatibility between the processes and institutions that produce proof in criminal cases, and the contexts and opportunities that characterize Dalit lifeworlds in India. On the other hand, false cases can be the result of competing visions of the Atrocities Act. While the Supreme Court holds the Act accountable to specific case-related facts, Dalits in Rajasthan see this law in particular, not every law, but this law in particular, as a tool to actively negotiate the historical power differentials that still define them. Ultimately, these insights force us to ask what the ultimate purpose of hate crime and anti-discrimination laws is, and who gets to define it, and how legal processes of proving must adapt to this purpose. Thank you very much.
Thank you so much, Sandhya. Maybe you stop sharing. Yes. Thank you. So that we can see each other. Judith apologizes. She had an emergency and she had to leave the room, so she's very sorry. And I think now I will give the floor to you, Natasha, to comment on Sandhya's paper.
Yeah, thank you so much to Julie and Judith and Allegra for this opportunity to engage Sandhya's work in honor of Sally Mary. And thank you, Sandhya, for your fascinating and exceptionally clear paper. I found your overarching question about the contradictions of the Prevention of Atrocities Act and anti-discrimination law more broadly very compelling and provocative, especially as it is your Dalit interlocutors who, in their use of the Atrocities Act, are the ones exposing the contradictions of individuated legal procedure and the realities of what you call the contextual truth of structural violence. So I'm going to organize my comments around the paper's key contributions, and I thought I'd start by drawing our attention to the name of the act and somewhat contradictory chronologies that it presumes and engenders. So I was sort of drawn to the name of the act as really foregrounding prevention of atrocities. And prevention, of course, is a future-oriented exercise. But as we learn in your ethnographic narrative, it's often in the filing for redress for already or previously enacted atrocities that we can stand to see future atrocities prevented. So there's a conundrum there as well. And then, of course, you show how the invocation of the act itself can be preventative, not of further atrocity, but of prolonged atrocity. So in the case of Anil's invocation of the act, he invokes the act as a threat to prokaram, to prevent, indefinite imprisonment. So in this case, the invocation of the act does not prevent the already occurred atrocity of casteist violence and casteist hierarchy writ large, which as Bantu recognizes would yield Anil's indefinite imprisonment. So rather, the invocation of the act here, it prevents a prolonged atrocity in an already uneven, atrocious social structure. And so I wonder if and how your interlocutors thought about anti-discrimination law as harm reduction rather than abolitionist. And I'm thinking of the way that anti-racist activists in the US discuss the compromises that come with working within the criminal justice system. And your citation of Parul Bakshi kind of made me think about this distinction between harm reductionist approaches and abolitionist approaches, and whether there's that conversation on the ground in Rajasthan. Outside of the abolition of casteism, then, the prevention, the power of the Atrocities Act is both this, you illustrate for us, as a spear and as a shield, is undergirded by the reality of casteist violence that structures the everyday lives of Dalits in Rajasthan. So I wonder if you could say more for us about the temporality of how Dalits in Junjunu recognize how the preventative dimensions of the act are situated in the past and present of casteism and offer alternative futures. And then I wanted to suggest that I think your key contribution about the relationship between truth and falsehood actually goes a bit further than the way that you synthesize it. So you say two things about this relationship. You say, one, that the act's procedural emphasis actually creates false cases and clashes with the local understandings of historical truth. And then secondly, you conclude that Dalit approaches to using this act, quote, throw doubt on the Supreme Court's implicit assumption that false and true cases can be effectively distinguished from one another. So I was very struck by your sketch of the ways that the folks you worked with understand truth to exceed the confines, the narrow confines of procedure, and how they wield procedure to rectify the wrongs of a wider contextual truth. And I was struck by your nice turn of phrase about how Dalits in Junjunu use the law, but not in legal ways. And this really is such a nice turn of phrase, and it kind of opens up thinking about law outside of the kind of narrow confines of courts. And they use law, you say, not in legal ways, but to prove the contextual truth of their disadvantage. Your quote is that Dalit approaches to and experiences with the POA challenge the dichotomy between true and false cases by highlighting how legal technologies, quote, produce facts in the service of a narrow truth that cannot reflect the realities of marginalized life worlds. So, but I think that you show us that they do more than just challenge the dichotomy. I think that the cases that you sketch out, put together with the wider context of caste oppression, ultimately suggest that there is no false case. And I think I would be curious to hear what you think about perhaps that bolder claim that your interlocutors are guiding you to, and saying that there is no false case. And perhaps you could push more strongly to comment on the limits of bureaucratic and judicial modes of veridiction. And I'm thinking, how can there be a false case when casteism is the climate or the total weather? And this is borrowing a phrase from Christina Sharp, who writes of anti-Blackness and white supremacy in the United States. She says that anti-Blackness and white supremacy is the total climate and the weather. So within this climate, there can be no falsehood in the naming of dominant caste oppression. And if Dalits are resisting the singularizing of atrocity that the act calls for, right, through mechanisms like individual reports, and challenge this dichotomy of false and true, then given that, I was wondering if you can think of a framework or a taxonomy that allows you to write and think outside of the true-false binary. And there are a few ways I identified in the paper that you're doing it. So right now, one way that you're thinking through this binary is capital T, historical truth of casteism, and then what lowercase t, the truth of individual interpersonal relations. So the relationship between Pokaram and Anil, and so on. And then another way that you do it, as I think, again, the temporality angle, you call the lowercase t truth immediate versus the capital T historical truth as contextual, has a longer duration. And then a last way that you address these multiple truths is through scale and texture. So another thing I picked up on were ideas of surface and deeper truth. So you say, where the surface truth is the truth of a singular case, well, this is what I had gleaned, that the surface truth is the truth of a singular case produced by courts and law enforcement. It, in your estimation, often does not bear relation to a deeper truth. And this deeper truth is the structures that define their day-to-day social and cultural life of prejudice and violence, is what you say. And you cite, and you have this formulation of surface accuracy, and you cite Evans on deeper truth. And then later, another kind of texture metaphor and thinking of the legal truth of law, you cite Derrida on flat, the flatness of legal truth, and the ironies of flat legal truth that's born out of systems of law and political power, and how this dismisses and obscures discrimination. So I'd be curious to hear about how you're conceptualizing truth as these two truths in your fieldwork, the truth of courts and the truth of structural inequity, as layered and working together, and perhaps not competing, but compatible and co-constitutive. And we can, in thinking about this, return to the Act's name again, and to see how it holds this contradiction that you identify between procedure and historical structural truth as a complex duality. So there's the longer name of the Act, which you tell us in the introduction, includes the name scheduled caste and scheduled tribes. And I think that that naming is really striking because it, in the Act, sort of in the design, is this recognition of a historical truth and of the historical contextual truth of caste oppression against scheduled caste Dalits and Adivasis. So despite the ways that procedural processes to rectify historical wrongs and atrocities, they individuate and abstract cases into standalone incidents, into, Anil's case or Shiv Kumar's case or Rajendra's case, but each iteration and enactment of the Act given that it's made for scheduled castes and scheduled tribes, underscores the historical truth of the exclusion of Dalits and Adivasis. So I guess I was wondering how you and others see the proof of the atrocity of casteism as the climate, as embedded in the act itself. And you know, why does that have to keep on being proved over and over again if the act itself recognizes it as a contextual truth? And at the same time, Rajendra's statement that I have, quote, tons of evidence, that I have no evidence, evinces the need for specific individual evidence pertaining to the singular incident of his father's murder, leading you to then say, quote, paradoxically then, evidentiary demands in POA cases can effectively replicate existing structural inequalities. So I was wondering how your analysis then points us to a more fundamental tension between liberal bureaucratic procedural regimes that privilege logics of proof, when the name and rationale for the act already, again, as I said earlier, contains the proof of structural injustice. And this reminds me of, I think it was in Allegra, Nayanika Mathur wrote an essay last year about bureaucratization in the context of Me Too and the How Journal, and wrote a piece about what counts as evidence and how, and even amongst, you know, anthropologists, where we privilege anecdotal evidence and historical patterns, we still require, when it comes to accusations around Me Too and sexual harassment, these modes of bureaucratized evidence. And so I think there's some disconnect there, and that mapped on to how you got us to kind of think about the context that engenders the act, then asking for individual citations. There's this disconnect. So this rejection of the true-false binary and simultaneity of the capital T truth and lowercase truth also really comes into view in Shiv Kumar's utterance, where he says, I lied, but there is truth in it. This is a really, you know, rich statement. And I had a few questions about it. And you have this really nice subheading in your paper called reasonable fiction. And on a first pass, I thought that was, you know, quite well put together. But I also wonder, is there a way to understand Shiv Kumar's lies if we try to understand his lie about beating up that man through the idiom of rationality and reason? Are we also then imposing the very liberal logics of reason that also suffocate and delimit the possibility for Dalit liberation within the act? And then I was curious about the statement in Hindi, Meri pitai mein sachai hai. So I noticed that the word that you're translating pitai as lies, and the word's not jute. And so I was wondering if maybe that's referential to beating up. And then if it is, it seems like Shiv Kumar is saying something wider too, that in my beating up of this man, there is truth. And in his beat, or, you know, in vague terms, his beating up, there's righteousness. And so you could read, maybe unpack that a bit more if you use the word bidai instead of jute. And then when you unpack this statement, you go on to say that, quote, for Shiv Kumar, the primary usefulness of the act lies in showing historical perpetrators of violence what it feels like to be a victim. And under the cloak, and you said this in your presentation too, of the act, Shiv Kumar enacts a form of caste impunity traditionally unattainable for people like himself, end quote. So this analysis led me to wonder and want to ask you more and ask you to share more about what kind of justice did your Dalit interlocutors imagine and marginalize? What are your thoughts on how, you know, marginalized people in this region, how they imagine justice more broadly? Is caste impunity justice? Is getting to act with impunity justice? And then, you know, Shiv Kumar's case was also reminiscent of Rajendra's comment about Sahi Log, or the right people. And as you say, you know, that these three cases that you tell us, they reveal to us that connections matter a lot. And I was also wondering if connections is how justice is imagined. So do people here imagine a future that is just, that where everyone has connections or no one needs connections to get things done. And again, is justice getting to act with impunity? And I wondered, on thinking more broadly in Rajasthan about caste and hierarchy. And, I know Anastasia Pilyavsky worked with conjures in a different area, but whether or not you have any thoughts on these ideas about hierarchy as social value or not. And it seems, you seem to have different material that suggests otherwise. So wrapping up now, I have a few standalone questions. And of course, we don't all have to discuss them now. These are just things to think about. And I'm sure people have many questions for you, so don't feel obliged to respond to them all now. But you do say that, you make a claim about how the folks that you worked with changed the legal format of the law. And I was wondering if you had more evidence for how that's happening empirically. Did you, observe or see or track any changes in how courts are operating in response to Dalit approaches to the law locally? Not so much from, the Supreme Court, but locally. Are there differences in procedure or anything that you noticed? I really appreciated the discussion of the limits of rule boundedness and rigidity. And, I think the citation of Plato and Ronald Dworkin was quite apt. But I wonder if, if you could also engage with, or you encountered Indic philosophers or any Dalit philosophers on the questions of dharma and moral ambiguity. And if those are folks that you could also cite, thinking subcontinentally about traditions of grappling with the grayness of law. And I had a question about the language of hate crime versus anti-discrimination. I am not familiar with how, hate crime is used in South Asia, but there are critiques in the US, at least, of hate crime as the proliferation of hate crime legislation as kind of individuating multiple minorities. And it works differently, of course, in South Asia. And this is different than the kind of insidious dominant caste critique that you tell us about at the beginning of your paper, about how this act promotes casteism, right? But there are, I'm thinking of Yasmin Nair, who and other people who write these queer critiques of inclusion and against equality and against hate crime legislation in the West that proliferates surveillance and of marginalized communities. And then I had a question about gender and caste. So what's really striking about all three of these stories is that they're all men, and there is one woman, Rekha, but the case is filed on her behalf by a man. And yeah, I have some other questions too, but I think I will stop. I also wondered if there's ways that Prevention of Atrocities Act also allows for any class action filing of, that would then challenge the individuation of the way that the act isolates structural oppression into, discrete incidents. And then the private sphere versus most of the cases that you identify seem to have addressed transgressions that happen in outside spaces, and how the jurisdiction of the act does or doesn't really confer to what people do in their private spaces in terms of engaging in casteist slurs and casteist violence. So thank you so much, Sandhya, for your really wonderful paper.
Thank you, Natasha, for this very thoughtful comments and for the time you took in, in putting them together for today's webinar. Thank you, Sandhya, for a fascinating paper. Perhaps you want to take a few minutes to answer to Natasha's questions before we open the floor to the rest of the group.
Yeah, thank you so much, Natasha. That was amazing. So much food for thought. And I'm afraid that in a couple of minutes, I cannot actually just answer all of that probably. But I'm actually going to take your last comments on hate crime legislation to kind of get a little bit into the naming and the history of the act and kind of the intentions, and just sort of unfold that. So this is based on this is a chapter from my PhD, and the PhD more generally does kind of it kind of discusses the Atrocities Act kind of at this intersection of anti-discrimination law and hate crime law, and kind of how it fits in and how it doesn't fit in. Because actually the way the law was conceptualized, and one of the main authors of it was a man named B.S. Krishnan, who I interviewed in Delhi, was he wanted that international law frameworks of atrocities, you know, which is usually kind of used to like things like genocide. He wanted that because he thought that terminology best captured kind of the scale and the persistent nature of what was actually going on, rather than kind of something like hate crime, which is like very individualistic often. But also because it, to him, was the most kind of explicit sort of term that he was familiar with. And he was not a lawyer, he was he worked in the civil service. A term that he said best captured this idea of violence flowing from the top to the bottom of like a social hierarchy. That's what he thought. And he never really kind of thought much about how this law fit in kind of into a broader global, you know, set of laws or legislation. But he did, it's a law that grew out of there were previous attempts to kind of like punish like practice of untouchability that didn't really work because they weren't specific enough. They were very much like, they were quite vague in that legal way of like, oh, you know, untouchability is not allowed. And so him and his team at the time, they decided that what they wanted is they wanted a law that wasn't about a broader concept, it was about specific actions. So this is a law that is very much like, you know, an atrocity can be anything from like harassing a Dalit woman or like to denying a Dalit like access to water or access to a temple or things like that. So you actually have like kind of civil things that are kind of suddenly like reframed as atrocities as well. And the reason for him was precisely what kind of this idea that you cannot actually capture caste violence in these like particular moments, but it is, as you say, it's the climate, it's the weather, it's everywhere, and pretty much all of these things that are done to Dalits are an expression of kind of that attitude, and that is still kind of like what he called that kind of casteism that's still prevailing in society. Unfortunately, however, and he kind of admitted this a little bit, where he kind of, to put it this way impolitely, sort of bit himself in the ass a little bit, was that because they kind of poured it into this criminal framework, actually, it kind of is now being kind of navigated and applied by people like judges, or, you know, investigated by people like the police, who are very insistent a lot of the time that it should adhere to the same procedures and the same kind of standards, for example, of criminal intent, like mens rea is a really big deal in this law, that other laws do. And actually that particular idea has helped a lot of people who were never keen on this law to begin with, people who find it very offensive to this idea of Indian progress, that there's still a law that claims that India hasn't overcome caste yet. People, you know, much like in the US, these discussions of like, we're not casteist anymore, people are stuck in the past, to actually kind of use that procedural part against the law. So actually just a couple of days ago, the Supreme Court, there was an appeal case in the Supreme Court where somebody who had raped a Dalit woman in Andhra Pradesh had been sentenced, and they kind of repealed that, saying, well, there is no evidence that this woman was raped only on the basis of the fact that she was a Dalit, so it doesn't apply. So actually what I sort of saw in Rajasthan, and what's really controversial, is it went from being a law with the initial idea that if there is violence committed against a Dalit or an Adivasi, we should assume that that is based on the fact that they belong to those communities, because inequality is also economic and structural, and not only, you know, about intention of hating in the mind, to a law where many higher courts, but also lower courts on a day-to-day basis, then say, well, if there is no evidence of this being on the basis of caste or on the basis of indigenous identity, and this law has so many harsher punishments than normal penal code issues, then it's very unfair to apply it unless it's very clear, to then kind of editing that out and making it into, well, we should now apply sort of mens rea, to now what's happening, which is, it's not even enough anymore for a lot of legal practitioners to prove that caste may have been part of the equation, but it needs to be the only equation. So actually what you see is that this like, just kind of like very idealistic idea that was there in the beginning has kind of actually been has like just like really banged his head against the wall through dealing with this kind of framework. And the reason, and so coming back to your issue about the name, this idea of prevention, so he called it the Prevention of Atrocities Act, or it was initially named the Prevention of Atrocities Act, because the idea was precisely that you said that we will punish sort of these moments of violence and hate, whether they are kind of physical, whether they are kind of like, you know, property related or anything else. And that will prevent further such violence, because this act is so harsh that nobody will want to do it anymore. And that's kind of where the prevention thing came in. And that's sort of the aim. And in terms of like broader anti-discrimination measures, that's kind of where that fits in. But then in terms of the actions that are being punished, they tend to be like what we kind of colloquially refer to kind of moments of like hate, or like, you know, that kind of like targeted violence bit. And there's a lot more that I could say about this, but just quickly, I love the different scales you kind of helped me sort of think through, you know, the temporality scale, the landscape scale, surface versus deeper. So the way my interlocutors usually talked about this, and it was very important for them actually, that we talk of this in terms of truth and not just in terms of justice, because they thought that part of justice was being believed that they were like, they would have justice if they finally were seen as people who were telling the truth. But they kind of really saw it in not a temporal way, but in kind of a landscape way. So they often talked about it in terms of like, you know, there's this whole life around this particular incident that is true, that is not being taken into consideration in this section or in this engagement or in this judgment. So they kind of had that kind of horizontal vision, but I love the idea of kind of like thinking of it more in terms of like also that kind of vertical idea of like temporality. They did often say things like, you know, the truth of the Supreme Court is not my truth. I have a different truth. I have a bigger truth sometimes. And actually for Shiv Kumar's particular quote, so the whole quote is, in Hindi is, "Maine jhoot bola, lekin meri pitai mein sachai hai." So it was a longer thing of like, I lied, but there is truth in my beating up this guy. And I think you're right, and I could bring that out much more, that he thought also that there was justice in him getting to do that kind of retaliation bit, that was kind of an element of that justice, which is, you know, interesting. It's a bit problematic. And then finally, just the thing I want to touch on, how do people kind of imagine or hope or think of justice? I think there's a number of things, and I think gender comes into that. I think a lot of the time there was difference in how justice or a better world through the Atrocities Act was imagined between different groups of people, but also among different gender groups. So for example, the people who were actually affected, survivors, tended to have a much more kind of practical idea of it, of like, justice means that I get to use this law in a way that makes my life better in my community. And that could actually then mean that they were really going for a court case, or it could mean that they were like more happy to like use it as leverage in a compromise, depending on what the situation was. Whereas these like activists who all, and these legal aid NGOs who all rally around this law had this like very clear idea of like, this law is a symbol, it's a symbol of what society should be like, it needs to be protected in its own right. And that they almost had this kind of idea of justice as being accountable to this law as a template for a better kind of tomorrow. And often actually those visions clashed with those of the people that they were kind of representing a lot of the time, because it led to different outcomes. And particularly where that came out, and there's actually a couple of chapters in the thesis that deal specifically with women, because of the way I experienced gender in Rajasthan, women usually, even if it was their cases, they weren't the one to go to police stations. They weren't the ones to do that, particularly also because a lot of the time the atrocity cases involving women did involve harassments and rape, and there's like issues of honor around that, and you know, making that public. But for many of them, justice was the idea that, and this is really kind of complicated, and I explore this in a different chapter, that you would be able to use this law to sort of restore your honor and kind of prove that you remain a kind of like honorable woman without having to have this like horrible tug of war around evidence where you kind of have to air all of your dirty laundry, that you would kind of get to a point socially where you would be believed as a Dalit woman and you wouldn't constantly be treated like you had to prove that you were actually raped and weren't just like sexually available. And so they had a really big like love and hate relationship with the law, because they often felt like it's an opportunity to kind of show the world by winning a case that I was actually raped, but at the same time, in order to do that, I have to expose so much that it almost makes it worse. And so they were just, I think a lot of women didn't quite know yet what they wanted from it.
Thank you, Sandhya. We have just a few minutes left, unfortunately, because the webinar is supposed to finish at 3:30. Perhaps we can take a bit longer. So I'd like to open the floor to questions. Anyone? Please jump in.
Can I jump in?
Yes, Marie-Bénédicte, of course, thanks.
I may not, I have to leave in 5 minutes sharp, so already apologies. Thank you for a fascinating paper, fascinating also response, so thank you. I mean, one small question. You are using their real names and the real locations and their real quotes, or?
I'm using their real quotes. I am using some people's real locations. I'm using nobody's real names, which I did negotiate kind of, in general, the rule was activists usually wanted, like legal aid NGOs and lawyers wanted their real names used, and people who had been affected obviously didn't. So none of these, apart from Rava village, which is the actual village, all of the villages are anonymized too. But that was particularly because Shiv Kumar had actually won his case, and he kind of was quite proud of the way he had won it, and he wanted me to. And his wife seemed to want that as well. But I'm still kind of unsure about like when it becomes a book, whether I should still oblige that or not. But all of the other people, Rajendra, particularly also women, are always anonymized. For the most part, everybody who isn't explicitly affiliated with an NGO or a public position has been anonymized, and even in those cases, statements that were made in confidence have been anonymized most of the time.
Yeah, okay. Yeah, no, I was surprised because you didn't say, and I thought it must be such sensitive topics that okay.
Thank you, Marie-Bénédicte. I saw Tejasvi. Sorry if I pronounced your name wrong. Sorry.
That's okay. That's okay. Hi, Sandhya. Thank you so much for your paper. I'm actually a PhD scholar in India whose work is on the Prevention of Atrocities Act. So I've been really looking forward for you to finish your work so that I can read up the paper and use it in my thesis. So thank you for that. I just had a couple of, I don't know, I guess these are questions and confusions that I've encountered in my work. So I thought, I'd use you as a sounding board more than anything. But so one of the things, just to pick it up from the question of gender and the way the truth splits, and just to extend, I think the reasoning that Natasha was offering, I feel like it extends to so many different domains of the law when you look at the judicial aspect of adjudication or the judicial discourse, so to speak.
Can you say that again?
Hello.
Tejasvi, I think you need to repeat your question. Is that what you're asking, Sandhya?
Can you guys hear me?
Yes, it's better now.
Yeah. Sorry. So I was just saying that, the metaphor of the truth splitting, I feel, runs across so many other domains. If you look at the judicial aspect, especially the adjudicatory one, when we look at what happens in courtrooms to atrocity cases. So one, I'm also wondering in terms of how the law knows. So if we think of law and how it understands caste in terms of the judge's perception of it, or lawyers. I, for example, was looking at the comparison between Mirchpur, where the Prevention of Atrocities Act was invoked, the incident of Mirchpur, which happened in Haryana, and some of the charges of atrocity were upheld and there were successful convictions for it, versus, let's say, an incident like Kherlanji, which didn't result in a successful conviction of an Atrocities Act. So now I was wondering, so I was reading the judgment and there was this comment that calling someone chamar while the conflict was happening and the violence was happening was identification rather than derogation. So what does that tell us about the nature, like we're talking about climate and atmosphere, when the word or the naming itself holds humiliation within it? And because the law assumes that those are split experiences, but are they essentially for the person who holds that identity? So in the sense that is another way to think about it, but also I'm wondering in the sense of how judges are able to know caste and humiliation. A lot of times, in fact, they invoke early anthropological or sociological understanding of caste in much the same way that, let's say, someone like Dumont talked about it, rather than someone like Ambedkar. So when we think about how the law knows and notions of injury and harm, I'm also confused because we have on one side the understanding offered by Anupama Rao that, it requires reperforming the injury and it, kind of distills the harm again. But on the other hand, we have Pratiksha's work that would say that caste is invisibilized in the adjudication of atrocity cases. And so is that also a contradiction, or how do we reconcile these? And I think the larger thing about false discourses, of course, is that it runs in the climate of, there are two people, according to me, when I speak to people who misuse the law. And it is, like we've talked about gender, Dalits and women. So it's either domestic violence cases or prevention of atrocity cases. And in fact, the 2018 ruling that you're talking about, the bench on that, Justice UU Lalit, I think a year before that, said the same terms, words for judgments on 498A, which is a domestic violence thing. And so it's interesting that they had instituted like a prejudicial committee to first, sift complaints through to see whether they were true or not before they even arrived anywhere. And they had constituted these community kind of like, courts where you'd have like social workers who'd go check whether the complaint was even authentic before police investigation began. So what that says about the law at an institutional level of splitting it in terms of its jurisdiction and power. So yeah, thank you.
Thanks so much for that. It's very cool to know that you're working on that. I've never met many people who are, so that's very, very awesome. So I think first of all, what you were just saying about the domestic violence bit, and this particularly also, for example, a lot of the time the Dowry Act, and this also being a law that it gets talked about a lot in terms of false cases. Absolutely, I experienced the same thing. What was very interesting a lot of the time in Rajasthan actually was that you sometimes had these cases where so one case that I saw was that, there was an intercaste marriage and the girl's family kind of really assaulted the man and he filed an atrocities case, and then her family then made the daughter who had run away with the Dalit man file a dowry case against him, and it was like a big, I don't know, just big kind of law battle. But I think that the false case narrative, I think that's why it's so insidious, because it is a narrative that only gets applied a lot of the time to people who are already in a structurally kind of not disadvantaged, in a weaker structural position. And particularly it gets employed in relation to laws that are there to rectify that position, right? And I think it's so much about what's so tricky about it is that the reason it plays out this way is because of all of the ways in which power or privilege or structural advantage are just not something that people can really often even understand how they have it and why they have it and what it means to kind of do these microaggressions, or and how all of these little actions add up to bigger actions, or what it means to be in a situation where you cannot navigate the landscape in the way that you as a person can. And so I think the problem with that false case narrative is that it always gets applied to things like caste which are so hard to grasp. Like, as you said, like, where is it? Where do you pinpoint it? It's there, we all know that. It's the same with the debates about racism as well. But like, is that enough of an aggressive thing? Is that just enough? Is that too little? Does that count? Does that not count? And there's very little understanding, and particularly still judicial understanding in India specifically, about like how that kind of builds up. And I think the Jamaat thing is such a great example of that, because I think, so what a lot of my interlocutors said was that if I want to call myself a Jamaat, that's fine, but other people do not get to say that to me. And they said it's not an identification. If it's an identification also, that's fine, but that identification is there to describe me as somebody who has a particular role in society, and it is offensive. And people saying, saying it in a thoughtless way still means that they get to talk to me in a thoughtless way. So it is still casteism. And the problem is, I think, a lot of the time, because you were asking about how judges or the police kind of define caste, is the problem is they really can't a lot of the time. And I think that's why they're so hell-bent. Even the well-intentioned kind of police officers I met, or the sort of district judges I met, were often hell-bent on this idea of intent, because they felt like that was the only way how they could even sort of, get at anything, get at the mind behind the action. And the problem, I think, that these kinds of laws face is that the whole idea of like race is a process, hate is a process, discrimination is a process, is that you cannot almost like find these individual points to deal with. And what that leads to is people really kind of either intentionally, because they're not very in favor of laws like this to begin with, or unintentionally kind of like harping on about particular categories that they feel like they need to hold on to get anywhere. But a lot of the ways in which then bureaucrats, or like district judges, session court judges in India try to prove caste was through the caste certificate, which was hilarious and really upsetting, because a lot of the time what they would do, and this is actually judges who in lower courts who meant quite well a lot of the time, who wanted to register something and kind of prosecute something under the Atrocities Act and convict under the Atrocities Act, was to ask the complainant to produce a caste certificate, because they thought that if that person came and produced a caste certificate, and they could say, well, this is clearly a member of this very low Valmiki caste, for example, then I as a judge can make a legitimate argument that caste played a factor. Ironically, though, most people who were coming forward with cases, very few people actually, at least in Rajasthan, were Dalits, actually have their caste certificate, and getting it requires you to go through a whole other bureaucratic, crazy labyrinth of things, which takes time and it takes money that people don't have. And a lot of the time, once again, another institution that they find very hard to navigate. So there are attempts to do it. So far, very few people really managed to, which is why initially when the act was introduced, the idea was, if it is, if it's an act committed against somebody who claims to be Dalit or claims to be the Adivasi, then that should be taken as the point of departure. But the bureaucratic machinery has not allowed that. And obviously that does expose, I would argue, some of the kind of unexamined sort of blind spots of caste or unexamined caste biases that are still circulating.
Thank you, Sandhya. It's already 37 past, so I will ask you to respond very quickly to these two last questions from Astrid and afterward Elizabeth. Astrid?
Yeah, thank you for the very fascinating and very detailed discussion today. I think so I'm presenting on truth from a very different angle next month, and I thought it was I really like also Natasha's comment highlighting what is beyond this binary of the truth. And I guess I'm wondering to what extent, so I find it quite interesting the point that you make about what is considered as evidence and who is able to gather that evidence and how that makes a case for truth or not. And I wonder what is different when people mobilize this specific legal tool and other legal tools within India, but also in other legal systems. is there such a difference? And the underlying questions, I'm wondering why you are putting so much ethical caveat around the second case. Is it not the case that in any legal system, like a creative mobilization of the instrument is what makes you win? And I wonder why, like at several occasions, you kind of, oh, but maybe that's not the right way. Like, why? Because is it not always the case? And yeah, I have more questions, but I'll leave it here. Thank you.
Okay, so thanks for that. That's very helpful. I'm just going to take the second one first, which is that, and I think you're probably right. I think what it is that because of what we just talked about, because there is this huge polarization around this law in India, and this idea that this idea of Dalits filing or lying is used so often in kind of political arguments to abolish this law, or to show that, caste is a thing of the past, and now, Dalits are asking for more and more and more, and they're all illegal. I think there's a part of me that's really hesitant to kind of reveal the fact that, Dalits too are kind of doing what everybody else is doing, but because I think there's potentially an anxiety on my part that if I put that out there, that it is going to be read by people that it is going to kind of fall into the wrong hands or something like that. So I think you're right that I probably need to step away from kind of that kind of anxious phrasing around it. I think that's probably where that comes from. And sorry, could you just briefly repeat the first point? I just had it.
But it was kind of the same thing. I was really curious why you were putting that caveat, because, so what was my question? Is to what extent is this different when people mobilize the Atrocity Act or other acts within India and beyond?
And I think just really briefly, I mean, in general, there's issues with the Indian legal system. It's hugely overworked. There's not enough judges per people. There's the numbers are very off. There's structural issues with police oversight. The Police Act is from ages ago. So there's all of that stuff. I think the thing that is particularly problematic about this law is that caste is not just about untouchability. Caste has had a hugely economic aspect to it over time, which means that for the most part, the group of Dalits who need to use this law are people who are still in a position where they can be attacked easily, or they can be taken advantage of easily, which means that they are often, and in most cases, very socioeconomically, they're not in a good position. They don't have any kind of capital, which means that actually in this particular case, that clash is very exaggerated between the people who need to use it and the people who are least able to use it because of who they are, and they're one and the same thing. And that's why it's so frustrating. But that doesn't mean that there aren't issues of that the Indian legal system isn't very kind of chaotic anyway, because it is. Yeah.
Thank you, Elizabeth. Your turn.
Okay, thank you very much. Absolutely fascinating paper and comments. I don't really have a question, but I just feel like I have to talk because listening to the whole presentation, there was so much similarity with a domestic violence case in Portugal that I've been following of a refugee couple, and this issue about the immediate factual truth getting in the way of justice. And there was so many parallels in the sense that the accusation of domestic violence, there's so many layers of reasoning that go on that are not available to the judge, that are not available, and that they're hidden, and so many pressures, for example, that are not able to be exposed during the court hearing. For example, the wife being put under pressure by the husband's family, and also her being concerned, feeling concerned about the consequences. If he gets a 5-year jail sentence, he won't be able to get Portuguese nationality, and he's still the father of the children, and so there still should be some kind of concern. And what was fascinating was that the police exaggerated the story. The police lied, and she could not lie. And she said, you know, what the police are saying is not true, because she had to say the truth, and they were trying to help. The fact that this thing about truth again, it's really fascinating, and it just seemed like it was really, although a completely different context, there were so many similarities. And so I was wondering, just as a sort of small question, was whether you know, to what degree, because following this case, what was so clear was that more important than the truth were the consequences, and we also heard that in your paper. So to what degree does that play an influence? It's like, but if I decide this, but it's like a lottery, because I don't know, you know, what the final decision is going to be. Is he going to get 5 years? Is he going to get 3 years? And in her case, he got no years whatsoever. He was actually absolved. Why? Because she was put under so much pressure that the judge viewed it. This is just normal quarreling between a couple, because she was trying to protect him, and because she didn't uphold what the police had said because they had lied. And so I was just wondering whether, you know, how much that also sort of plays a role. But it's a small question. But I just really wanted to share the similarity, because it was really very, very similar in many things. Thank you.
Thank you. I think that's great. I also think it's always really great to see that there are clearly, you know, some of this is very specific to India and caste, and then other bits there is clearly like, and we all know this, but it's always really nice to see this ethnographically play out kind of everywhere, where you see that relationship between kind of people who have been structurally kind of in a weaker position, who are now dealing with law kind of to help themselves, and how that's playing out, and how there are kind of these similarities and like these like similar barriers everywhere, even if the cultural context has very specific moments of that. So I think that's really interesting. I think in terms of consequences, I think one thing that we haven't talked about at all, and I think that I just kind of need to put it out here, is that this has been a paper that's very much about all the things that don't work, right? But people are really quite hopeful towards this law, whether that's because of its symbolic value, but also because of actually it does give them a lot of time, quite a lot of good leverage outside of court settings, like filing cases, as we saw with Anil. Like it can be like something that really helps you in community negotiation. It can lead to like certain bits of financial compensations through compromises, through settlements, through all of that. And so a lot of the time, actually, the consequences people were thinking about, sometimes they were purely legal, and sometimes they were more in terms of like, okay, maybe I file this case, maybe I pursue it to a certain point, maybe that does something, maybe that does something better. Like particularly often, like in cases that involve women and rape, it was often like, you file it, maybe maybe these dudes get arrested, maybe that scares them enough to not touch our women again. Maybe you let them rot in jail for a while. We probably think they will never get convicted. We kind of know that, but actually let's give them a good scare, and let's do that, which then also, but then that's really so problematic, because of all of these settlements then come out of that leads to wider public discourse then of like, look, Dalits are filing cases and withdrawing cases, they're like playing with the game. So you have these practical consequences, which are good in kind of the immediate social world, but then they kind of lead to like longer anxieties and kind of longer polarizations down the line in the broader political sphere. So that's something people were really trying to negotiate, and where like activists and survivors often clashed, because activists were so concerned with the credibility of the law.
Thank you so much, Sandhya. Thank you everyone for joining our webinar. I think we will have to stop here, even though I'm sure there are many more questions that could be asked, but we've overpassed the time by 20 minutes. So I feel we need to conclude. So I would like to invite you to join us on the 23rd of April. So it's in 2 weeks, and we'll have Liselotte Vian from the Universitat Carlos III de Madrid, talking about indigenous water ontologies, and her paper will be discussed by Andrea Ballestero from Rice University. Thank you for joining us, and see you at our next webinar. Bye-bye.